All right, everybody, welcome to the bankruptcy process module. So what we are going to do is we're going to talk about, the bankruptcy process. This is primarily from the debtor's perspective. We're going to roll through the process that a debtor experiences from the time that they initiate a bankruptcy by filing the bankruptcy petition, and we're going to take it through its natural end, which there are actually there are several different ways a bankruptcy can end, but we'll give you enough detail for what you're going to need to make sense to you. We're also going to talk a little bit about the roles of the different players in the bankruptcy process. So we're going to talk a little bit about things like what the judge does and what the bankruptcy trustee does. All right. So starting the bankruptcy proceeding, every bankruptcy begins with someone filing a petition. As I stated in the bankruptcy introduction course, 99.9% of the time, that's going to be the debtor filing the bankruptcy seeking relief. And you'll recall that these bankruptcy filings are always done in a U.S., it's a federal bankruptcy court. Attorneys are not required for a debtor to file a bankruptcy, and we frequently see bankruptcies that were filed without an attorney, or how we refer to it as a pro se bankruptcy. It doesn't matter whether you include an attorney or not. As I stated in that introduction module, the automatic stay goes into place right away. Any creditor has any kind of knowledge that the tenant has filed or has even if the creditor suspects that the tenant has filed that bankruptcy, that automatic stay is going to be in place. What should happen next is the debtor should notify his or her creditors of the fact that they've filed bankruptcy, so that the debtor can ensure that the creditors understand that. After that, there's the debtor in some cases is going to be required to pay a filing fee. They're almost always going to have to provide several financial documents, pay stubs, taxes, pay stubs, taxes, that sort of thing. And in the case of an individual bankruptcy, the debtor is also going to have to take a financial management course. So let's talk about what the trustee does. Or who the trustee is, I should say. So the trustee is typically going to be a local attorney. Appointments for trustees are usually automatic. The courts have a prearranged relationship with an attorney who's almost always going to be a very experienced bankruptcy attorney, and that attorney's the work is kind of farmed out to the trustee. Often one attorney within a bankruptcy district. For example, Texas has 4 districts: North, South, East, and West. The Eastern districts: Northern, Eastern, Western, Southern, and I forgot which one I didn't mention there. But anyway, you get the drift. So typically what you're going to see happen is you're going to have one attorney who handles all of the Chapter 7s. You might have another one. You're typically going to have another one who handles all the Chapter 13s. You might have multiple attorneys within the same region who handle those if it's a higher population area. The trustee you can think of as an agent of the court. It's like they do a lot of the court's legwork on the bankruptcy process. It almost feels like, in many cases, the trustee is working for the judge. However, the trustee is still independent from the judge. He's not necessarily an employee of the judge. The trustee still has a lot of independence. The trustee can and will recommend dismissal of a bankruptcy case if the debtor isn't filing the rules that the debtor is supposed to file. And the trustee can also do things like request sanctions. Those are usually money damages against any party. That can be a creditor or a debtor. So bankruptcy is almost, it's kind of like the trustee's like an agent of the court, but he's also like a third party to the whole bankruptcy process. One of the next steps that happens with many creditors is they file something called a proof of claim, and that's where the creditor is pretty much saying, hey, I'm here, I'm one of the creditors. The debtor should have identified all of the debtor's creditors when the debtor filed bankruptcy, but sometimes that doesn't necessarily happen. The proof of claim establishes that that a specific creditor is interested in getting some type of reimbursement out of the bankruptcy process. One of the challenges that you have in bankruptcy sometimes is getting the parties to agree as to how much the debtor owes. Sometimes the debtor will have a different idea on what the payoff balance on his loan should be, for example. Often filing a proof of claim is pointless for a landlord. So often with our clients, we aren't filing proofs of claim, mainly because the tenants typically owe maybe a couple $1,000s. If the trustee sets up a payment plan for us, well, hey, that our client might be getting $23 payments a month, and often in the Chapter 13, Chapter 13s will frequently only last 3-5 months. It's just not worth it, in my opinion. Different attorneys will disagree with me about this, but in my opinion, I don't think it's worth it to do that, because for one of our clients to pay us to do a proof of claim, because the amount of time I put into it and bill the client for it's probably going to exceed the money that our client's going to get out of those what are called trustee payments, those distributions. These cases, Chapter 13 cases in particular, the reorganizations, are almost always going to be dismissed or liquidated, or one thing I've left off, converted into a Chapter 7 case, and that's done to buy the tenant more time. So we can usually get what it is we really want without filing a proof of claim. And what we want for our client is to either get the tenant paying the full monthly rent payment on a going forward basis again, and doing it in a way that we can enforce. So if the tenant screws up, we have a very, very fast remedy, and I'll talk about that in another module. That's really ultimately our objective. Our first priority is getting our client paid again, if need be, getting the property back in our client's hands, and then money's often kind of plays second fiddle to that priority. Another step in the next step in the bankruptcy process is called the meeting of creditors, and that's kind of an opportunity for the creditors to sit down and really ask the debtor questions and confirm the debtor should be filing bankruptcy at all. Traditionally, this is always done in the presence of the trustee. It's not done in the presence of a judge. There is a court reporter there typically, and usually this is conducted at the trustee's office, and it's conducted by the trustee. There isn't a lot to it. Creditors normally don't go to those meetings, although if we have a tenant who's a particular pain in the neck, it might be worth it for us to go there and maybe ask the debtor a couple of difficult questions. But for the most part, there's very little for the landlord to gain anything by having us attend those meetings. And it kind of goes back to that proof of claim concept of, I don't want to charge my client for time doing something that's going to provide just no meaningful return on his investment. There is no harm if a creditor, if one of our landlords doesn't attend that meeting, or more accurately, doesn't have us as their attorney attend those meetings. So confirmation, different type of confirmation than what we're talking about in that picture. Court signs off or confirms the proposed bankruptcy plan, and that bankruptcy plan, it might be a schedule of payments to each creditor, or it might be a list of credit. If it's Chapter 7 where there's liquidation, it might be a list of debtors or creditors who are having their debts entirely discharged or forgiven. In other words, tenants, the debtor's never going to have to pay those payments back. So often there's a fight between the creditors and the debtors' attorneys, and sometimes even the trustee gets involved in those fights. But so the process is the process involves the court, the judge signing off that plan. Typically, the debtor is one. The debtor will be the one who initiates this process, who will file documentation with the court proposing a plan on how to manage the debtor's debts. And like I said, Chapter 7, typically the unsecured debts, and we're going to talk about what that means in a second, are discharged. They vaporize, essentially. In Chapter 13, there are typically reductions in the debtor's interest rates, and there might even be extensions on the period of time the debtor has to pay back the principal balance of those debts. So in the judge's role here is to consider the various objections that might arise from the creditors or even from the trustee as to the debtor's proposed bankruptcy plan. And the judge might look at plans that other parties have presented to the court. So let's talk real quick about the difference between the judge's role and the trustee's role. I know this is sometimes confusing for attorneys. So the judge's role is to rule on motions that the debtor, the creditor, or the trustee has brought. Sometimes it's not even motions. Sometimes it's other pleadings that might be objections. And the judge is going to be applying the bankruptcy code, in some cases procedural laws, how we're going to go about managing the case, to the various legal controversies that might arise in the bankruptcy case. The judge's role, of course, is also to sign off on that bankruptcy plan, and the judge will also either approve or deny the dismissal of the case, whether the dismissal arises because the bankruptcy has reached its natural end because the debtor has paid off all of the payments under the plan, or if the debtor has failed to do something that the debtor was required to do during the bankruptcy process, and that latter type of dismissal for cause is a very frequent occurrence, especially in Chapter 13 cases. So let's talk real quick about what the trustee does. So the trustee is responsible for moving the bankruptcy process along in many respects. If the tenant starts the bankruptcy process but fails to file the required financial information, those pay stubs, those taxes, that kind of thing. A big one is the tenant or the debtor failing to complete his financial responsibility course. If the debtor fails to do that, the trustee is there to kind of goose the process along, and the trustee will do things like file a dismissal if the debtor starts missing deadlines. Now, if the debtor misses a deadline, remember, this is a court of mercy. It's not the end of the world. If the debtor comes back and does what he's supposed to, even after the trustees filed a motion to dismiss, the court will often ignore the debtor's transgression there. So, okay, we kind of covered that. The trustee's role is also to make recommendations. The trustee, in some respects, kind of acts as an advisor to the judge in these cases. And the trustee also manages any payments that the debtor makes. So if the debtor provides some kind of asset or let's say that the trustee could be involved in something like taking possession of an extra vehicle that the debtor has, and the trustee's office might coordinate the sale of that vehicle and take the funds from that sale and distribute it based on a plan to the various creditors in the bankruptcy. Usually, that's not a very common occurrence. Usually, it's money that we're talking. Usually, it's cash. So, the end of the bankruptcy line. This, in the case of a Chapter 13, the debtor starts making payments. Those are typically deducted from the debtor's paychecks if he gets automatic payments. Those payments go, like I said, directly to the trustee, and the trustee distributes those portions to the creditor. And that process continues until either, for whatever reason, the debtor stops making those payments or the debts are entirely paid off. And that latter scenario is kind of rare with Chapter 13. Another very common occurrence is that the Chapter 13 is converted by the debtor's attorney into a Chapter 7. My opinion, don't quote me on this, some bankruptcy attorneys get sensitive about this kind of thing, but my opinion, I think a lot of bankruptcy attorneys do that because that's a good way for them to capture a second fee. In the case of a Chapter 7 bankruptcy, the unsecured debts are typically liquidated. They vaporize, they go away. The secured debtors, you can think of homes and automobiles, are typically reinstated in some manner. The debtor might sign something called a reaffirmation agreement, where as long as the debtor does things like make good on the arrearages or go on a payment plan for those arrearages, then he'll pick up on that. The debtor will pick up on his monthly payments, like the bankruptcy never happened or like he never fell behind. Alternatively, they might modify the terms. They might roll the arrearage payments into what is essentially a new contract, a contract with modified terms, so that the debtor can get caught up and eventually pay off everything, the past interest and principal as scheduled. Okay, so the end. Next up, we're going to talk about the process of a creditor going in and getting the automatic stay lifted.